Well, Tim Santoni, I have an investigation and background screening company. Thanks to Catherine for inviting me to speak today. The talk I want to give is a little bit about what you don't know can hurt you. In the background screening world, it's more about more than it's about the records. It's also about processes and procedures and compliance, as many of you guys can attest. So without further ado, I'll jump right into it. Just a little bit about me, licensed investigator. We have an investigation and a background screening firm, been doing it for quite a while. I'm also an expert witness, and I work with clients in the legal space, insurance, brands, across the board. And there's a few clients that we work with, so people always ask, who do you work with? We work with mostly people that are in compliant related spaces, healthcare, government, IT, finance, also some nonprofits. But just to get a sense of who it is we work with, we also work with professional service firms. And the team that stands behind us allows us to do that, or some people on here. Nicole, who you see up there, is also in Provisors. So the reason I'm passionate about this conversation is because for me, it's about risk mitigation. So throughout the life cycle of businesses, from startup to growth to expansion to exit, there's risk at all phases. Oh, thank you. I don't know if that's gonna work. So little story about our business. So in the investigation world, there's a lot of times where risk and claims arise, litigation, employment, embezzlement, fraud, workers' comp. Those things come up, we get involved, we investigate those things, and we determine that the employer has not done a good job of vetting these employees for a variety of reasons. And when that happens, the exposure and the risk is astronomical to those clients. So I think that by screening your employees, your vendors, your partners, and your consultants, you can mitigate that exposure as you scale and grow. It also increases the value of the business as you look to exit. So at all phases, it's super, super important. And so that's kind of why I do what I do and why I believe it's so important. To me, it's the best business insurance that anyone can have. So first off, we're going to take a little bit of a quiz. I'm not to embarrass anybody, but it's kind of a foundational element of this conversation, just so kind of we're all on the same page. We understand kind of what rules we're talking about, and if there's one thing that you take away and bring back to a client or to your business about being more compliant and doing things effectively, then I've done my job. Okay. So if you guys know the answers to these things, we're not keeping score, but first off, do background screening companies have special databases allow us to access criminal records instantly? Anybody? And why is that?
Because each county has their own system. Some are paper-based. It's all over them.
And what if that background screening company is also a private investigation firm? Wouldn't they have special access?
They have to go look, right?
Yeah, so the bottom line is there's no special instant database. We've got to look county by county, state by state. So good answer on that one. Another true false here. In California, our applicants must authorize the background check after the conditional offer, and they're also entitled to a copy of the report. True. Yeah, a lot of business owners out there think that, well, I want to screen people ahead of time because I don't want to get involved, and I don't want to show them what I'm doing. I don't want to give them a copy of the report because I don't, if I don't want to hire them, I want to be sneaky. In California especially, you got to follow this rule. All right, see if we get a little tougher here. The National Criminal Database, or as we like to call it, the multi-jurisdictional criminal search, includes all county, district, state, and federal cases. So you guys all got this, but most of our clients think that by doing a national search that you're going to cover every and all record in every courthouse, every district across the whole country, and they come back to us all the time. The reason I bring this up is because a lot of people forget about federal cases, and federal cases, what I call are Googleable cases. Those are the big things that happen: embezzlement, things that go across state lines, drug-related charges, trafficking, a lot of high-level crimes involving money, crossing state lines. And those typically, when you do a Google search, they're going to pop up. But a lot of people say, well, I did the national search, why didn't they come up? And then we have to explain to them why federal searches are so important. Okay. On this one, in California, arrest records are reportable on a background check. What do you guys think? Always, never, if arrest results in a felony, or if the arrest results in a felony or a misdemeanor? What do we got? D? Anyone else?
Be like boy.
Be like boy, never. Catherine doesn't know. So the correct answer is B. In California, arrest records are never reportable. They're an indicator of potential crime, but remember, California is is kind of restrictive in that approach. And so an arrest record is something to search for. It's an indication that a case might be filed. But remember, you could be arrested and not charged, and you could be charged but then not found guilty, or they could dismiss the case. So arrest records are never reportable. Yes. Again, in California, we're talking about here specifically, an applicant on the sex offender registry is never eligible for employment. And we've got a couple different answers here. So we got yes, we got no, only if the offense occurred in the last 7 years, or only if it involves a position that involves contact with sensitive population. What is it? D, which is correct. So it's actually not even reportable. Well, we could report it, but the employer cannot use this information unless the applicant is going to work where there's a sensitive population, elders, children, things like that. If they're working in a warehouse, they really should not be using that information as a reason not to hire, which is very troubling in some situations for a lot of employers. This one's one of my favorites. We all know that social media is rampant, but in the HR and hiring space, social media searches conducted by HR professionals are permitted if, and we're talking about in the background screening context, right? Discreetly, so the applicant doesn't find out. If the FCRA and state reporting rules are followed, the social media accounts are public, or the applicant provides the usernames and passwords for all those accounts. C. You got C? Anyone else? So you guys are both right. So it's B and C. So when you're looking at social media, the more important thing is that you're not supposed to ask them for those social media accounts and their passwords. That's a no-no. But they do need to be public in order to be searched, and you must follow, in essence, a 3-point identification scale to make sure that the information reported is in a compliant manner that can be used. It's not going to create discrimination for religious, age, or any other situation. So good job, guys. You guys are. And then this one comes up quite a lot for all you workers' comp brokers out there. Searching for workers' comp claims as part of a pre-employment background check is a recommended practice. And why is it false?
Don't hire someone because of a workers' comp claim at a previous employer.
But wait a minute though, I don't want to hire, Catherine, I don't want to hire people in my business that have prior claims, because then they're going to file a claim there and then I'm going to be on the hook for it, and then my X-mod's going to go up. So this comes up quite often, and usually business employers don't have someone like Catherine to mentor them. So we have to indicate them that it's a bad practice. And in California, for instance, there's not a fraud abuse system of checking. Litigated claims can be searched for, but they're not flagged saying fraud, but you can see that they come up. But non-litigated claims are very difficult to uncover and expensive and not a recommended practice. But more importantly, it's crucial that the person is fit physically for the position. So a lift test and a physical to making sure that the person at the time of hire is physically fit for the job is way more important to create a baseline than running a check to see if they have prior workers' comp claims, because it's indicative of a prior injury, but it's not going to tell you, if they can do the job and meet the physical requirements. And then this is the last question on the quiz. This really relates to FBI NCIC database that we think about when it comes to fingerprinting. And this is a true-false question, but I'll give you guys a quick answer just so we can move along. This is true. According to surveys and everything else, just so you guys understand, the FBI and NCIC is a conglomerate of a bunch of different databases. They're not always accurate, correct, and inclusive, although we rely on fingerprint scanning for a lot of sensitive positions. It's not a recommended practice for private employers. Okay, so the trap that we run into is the fact that we're hiring people and we're doing things in our business that create risk. So I'm going to kind of walk through our processes, some compliance stuff, and take it from there. So like I mentioned before, there's a lot of reasons why people might run a background check. Well, maybe because their HR consultant advised it, they've been stolen from, they've been embezzled for, maybe they have a history of workers' comp claims. But according to a survey by the PBSA, these are the three main reasons why employers are going to conduct background checks, right? Protecting the safety of the employees and the customers, the quality of the hires, and they're mandated by law. So, right, if we're in finance, IT, healthcare, there could be requirements that they're audited and reviewed, and in order to do business, they must conduct background checks. In the insurance world, there's no reduction of premium for doing background checks, but showing that you have a process in place is something that you can share with your broker and your team to mitigate that. And again, this kind of is back to the point that I think it's also important that it's a reputational thing. And a lot of people are under the assumption that background checks slow hiring and deter people from working for them. And I would argue it's a great process to follow. And if people do have criminal records, they will automatically opt out and not continue the process. It's not because of the fact that it's slow or it's deterring them, right? It's deterring them from actually going forth with that job. So in California, you guys familiar with ban the box? Ban the box really just bans the question on an application about has this applicant or this potential applicant been involved in any cases or criminal activity of law enforcement. It doesn't ban background checks, just so we're totally clear. And actually, after there's a conditional offer, you can ask that question, which we advise a lot of employers to do because it can be helpful. Although you have to verify what's been provided even after the offer, it's very, very helpful. So like I said earlier, in the conditional offer is required in order to move forward. Especially in California, remember we have many state rules and we also have county and city rules. And if the client's not using the electronic application to obtain authorizations and disclosures, they're going to be failing in the compliance world because they don't have obtained enough information about where the applicant lives, works, and in order to prompt them with the right authorizations and disclosures. And so that's crucial. If they're going to use paper, it'd be a stack of paper about this big. So if you have any clients that are using paper forms to run background checks, tell them there is definitely a better way. And that way you're ensuring compliance. And again, it goes back to risk mitigation. There's no point of running background checks in an organization and doing it improperly, because then you're going to get improper hiring practices, discrimination claims, and they're going to come back at you for just not following basic processes when all you were trying to do is mitigate risk in your business anyway. So doing them improperly is a really, really bad idea. If you're going to do them improperly, don't do them, right? It just doesn't make a lot of sense. So what can we report? We talked about arrest records earlier. We cannot report those, but the question here is it depends. It depends on where the employer is located and where the applicant will be working. And really what it comes down to is where that applicant will actually have their boots on the ground. So remote workers, if they're working for an employer in California, but they're working in Texas, Texas is the jurisdiction to follow, right? If they're in California and they're working in California, then California is the jurisdiction to follow. The overarching federal law is the FCRA, the Fair Credit Reporting Act. Even though we're not oftentimes providing credit reports, the FCRA does apply, and that impacts what's reported at the federal level. So what's up, John?
Yeah, so why are they only allowed, so I'm placing financial, right? They have access to cash, credit cards. Why is it that the state limits us to 7 years? I mean, if somebody was convicted of embezzlement 15 years ago, a future employer should be able to have access to that information. I just don't understand why they limit it to 7 years.
Yeah, so John's question is that California is a 7-year only state, which means 7 years from time of, on convicted cases from time of disposition, incarceration, or formal parole if you can prove that. So if somebody was convicted for embezzlement and did time 15 years ago, we cannot report it. And it's just a prevailing theme, and I'll show you the states. There's several states that follow that same guidance, which is, it doesn't make any sense because if you have California, it's a 7-year only state, but you have someone like Texas or Colorado. So if the applicant was in those states, that would be reportable because convictions are reported for as long as they're available. Even non-convictions are reportable for up to 7 years. So it's just very limiting, right? And I don't know the exact reason. So it's just the trend that we're going towards. And also now cities and counties like Los Angeles have specific rules about reporting that are changing what you can report. So drug-related offenses are no longer reportable if there's rehabilitation because of legalization of marijuana and things like that. So now there's all these different rules on, of course, the topic is what you don't know can hurt you, but sometimes having too much information can also hurt you. And so that's why following compliant guidelines and regulations as it relates to backgrounds is super, super important for employers. And so to John's point, these are the 7-year only states. So if the applicant is doing work in these states or works for an employer that's based in these states, this is what you're looking at. And so your limitations, and that I would say that list will it will continue to grow and there'll be more restrictions, especially when we have clean slate laws, even in Michigan and other states where they're wiping out records altogether. So as a background screening company, our goal from a quality assurance and adjudication perspective is to report information the employer can use to make the hire, right? If we provide them with information that they should not have, and they make a hiring decision based on that, we're creating risk and liability for them and for us. And so that's what we're trying to do. And we're trying to follow all these rules that are in place. We talked about the 7-year convictions only, the limitations on the sex offender registry. It's very, very important too from a compliance perspective in California. All applicants are entitled to a consumer copy, and they are entitled to contest the findings in those consumer copies. If the employer elects to take adverse action, there is a pre-adverse and adverse action process that they must follow. The background screening company that they work with should have this stuff built in to help them with that process. And there's a timing requirement and procedures that must be followed in order to make that happen. So if the employer decides to not move forward with an offer based on the findings of a background check, they can't just pull the offer. There's a formal process that has to take place here in California.
Do you kind of just provide everything and then it's up to the employer to make sure they're following the rules, or is what you're providing employers keeping them out of trouble, so to speak?
So yeah, so it's a good question. Could everyone hear that? She's asking if all the stuff that we provide is kind of employer reviewed. So we have general counsel that reviews our forms. We provide them to our clients and let them know what the process is, and if they want to make modifications, they can. So from our authorizations and disclosure forms, they're updated on an annual basis typically. And then for any of kind of the pre-adverse, adverse action, those letters, if the clients want something specific, we can modify that, but it's all loaded in and we review and we let them know in advance what that looks like, and they have to sign off that they understand what they are, what those are ahead of time. That way they know what they're using. Does that answer your question?
Yeah.
Okay. Yes.
So, an HR consulting firm, and every so often our clients will say, hey, can you just handle this background check for us and then just let us know the results?
Okay, so the question is like HR people that are doing hiring, or they want them to do the background check on their behalf and then to share with them the results. So this is a tricky situation because technically speaking, the employer needs to be the person of record because they're hiring and they're making the hiring decision. They're the ones that should be running the background. They need to notify the applicant that they're the ones running it and they need to make the decision. So we have HR consultants on our platform that administer for their clients, but their clients are loaded into the system so that all the forms and authorizations and all the different documentation follow that path. And then also too, the employer needs to make the hiring decision because you may not know their hiring practices, you may not know risk factors, you may not know what their processes are. So it's best for them to do that individually, even if it's for a one-off. Does that answer your question? So
Leo's got a question.
When you order a background check, is it just, this is the background check, this is in it, or do you have it on gold, silver, bronze, different levels?
it's a great question, and I'm going to answer it all in like 2 slides. Lay it all out for you. So the landscape today, so if someone says they're doing instant background checks, that's a red flag because there's no way to, especially for California stuff, there's not a statewide repository. The National Criminal Database for California and many other states is like the Swiss cheese of database kind of searches in terms of the length of time before it's updated and the records that are there. The other piece with all of AI generated content in terms of identification, diplomas, and verifications of employment, verifying that we're screening the right person has become critically important because if they provide false information, we're screening the wrong person, which may be clear. So we're adopting now identity verification where we're using an application to take a photo of the person and compare it to a state issued ID to make sure that before we go forward, we've at least confirmed that. One of the challenges with that is some states don't even require updated photos. So in rare circumstances, we can't match that, but it's a best practice going forward. And we're developing that with a lot of our clients because we want to make sure we're screening the person, especially with virtual hires that they never see. They would have no way to know who the person is. And the other challenging thing for California, I'm sure you attorneys are aware of, there's a case called Hamrick out of Riverside, which in essence, privacy attorneys argued that criminals shouldn't have their information, their full names, dates of birth, and driver's license should not be part of the criminal index. And they won the case. And so it's forced every county clerk in California to redact full dates of birth, which has extended the timeline to verify records, and it's increased the cost for employers. And so we're encouraging employers we're fighting it with a lot of different, like PBSA organization, but it's really a challenge because if we can't verify a record, because we don't have a full date of birth, we have to request the record from the clerk, which then has to be pulled. In jurisdictions like Los Angeles, we have very common names like a Smith or a Rodriguez or Jones. those can take a long time, and usually it's false positives that are delaying people from being employed. It's not a situation where it's helping us to, rule out people from jobs because of records. And again, the compliance challenges, I say California and New York are the two. If you have any clients in New York, make sure they're checking with an HR consultant and an employment attorney, understand the two-step process. In New York, it's even more complicated. You must break apart the criminal background check from all the references and verifications in 2 steps, and they have to be sequential. Otherwise, they can get in big trouble because, again, it creates a discriminatory hiring practice, and it's a mess. So if you have an employer in California that's hiring someone in New York, those rules would apply, and they need to be aware of those things, so it's tricky. Okay, Leo, right? This is for you. All right, so screening packages, what do we include? So at a basic level, we're running an SSN trace, an address history, developing potential names and addresses so we know where to look. We are going to check the multi-jurisdictional criminal database, and because that could pull back information or indications of arrest and where to look for records. And then we're checking the sex offender registry, and then we're running the county level criminal history search, as well as usually a driving report. And the reason driving reports is crucial is not because we want to know if they have driving related infractions, but it's for identification purposes. We can get a full legal name off their driver's license, and it may indicate to us where to look for potential criminal cases, a DUI as an example, or violations that occur with the DMV across state lines. So if they were in California and went to Arizona, we may get a hit there as well. And just a heads up, the SSN trace is not a way to verify identity. It's just a matter of running a social to determine when it was issued and where. It's an indicator that someone could potentially be using a false social. For instance, if the social provided is issued to someone who's deceased, or it was issued, for instance, 10 years before they were born, things like that are indicators, but it's really just a tool for us to actually figure out where to look for records in the event that the applicant is not forthcoming about their address history and their names they've used in the past, right? This is more of a complete package. This includes all the stuff on the standard, but we're talking about federal. Super important to look at that. And we also want to look at the driving record. Generally speaking, people have lived in 2.1 counties over their prior 7-year period. So you figure if you conduct searches of at least 2 to 3 counties of prior residence, going back that 7 years, you're covering wherever they might have resided. However, if they moved recently, they don't provide an updated address, it's very possible that you can miss a county search. And so you're running all those different searches to try and create this web of where to look to uncover as much information as possible. Add-on services, these are the things that we always recommend and are specific to certain types of industries. In California, reference checks aren't so much of a thing, but in East Coast states, it is important, especially for nonprofits and people that are have certain requirements with their organizations. And again, the identity verification is a huge one. Drug screening is still super important. And in California, it's become a little bit more challenging because of the prevailing laws and the fact that marijuana has become legal. So a lot of clients have gotten away from drug screening or at least testing for marijuana.
Can I ask social media searches? I mean, I can make some assumptions on what you might be trying to flag for employers, but what are most employers typically looking at?
Sure. So the question is on social media searches, what are we really looking for and what are we flagging? What do employers care about? So it really comes down to a few things. So we can look for words, and we can look for images, and we're looking for things of harassing behavior, violence, guns, alcohol use, profanity, and then we take all that information, run it through a tool, and then we give them a score, and then we flag those things that they should look at, right? Because sometimes it may be a false positive, for instance, that there was a bottle of alcohol, but you weren't drinking it, but it shows up in the picture as an example. But those are things that are important to them, to be honest, it's really it's a difficult tool to assess because it's a subjective decision about what's in there. But a lot of people want to do it as a way to let the potential employee know that they care about this, they're looking at it, and it's important to them.
Well, I imagine it probably helps them with culture fit as well.
Right. The challenge, just to be quite honest, is that how do you say I'm not going to hire you because of what I found on your social media unless you said you killed somebody, right? So it's egregious stuff, but it of course it could initiate a conversation or it could so.
Sorry, just to add to that, I'm just thinking about with politics and stuff, if a company is very specifically on one side, or maybe they're a nonprofit who's focused like Planned Parenthood, they might look at social media and say, you're, a Republican, you can't work here. Like, couldn't that open the door for just a lot of
Yeah, so I mean there's obviously indication of those tendencies in there, but the idea is to scrape that stuff out so that it's really based on what they're actually posting and sharing in terms of the words that could cause rise to that. But of course it could. And again, I think it's more about what's important. Yeah, so we have a way to configure the algorithm so that we have employers that want to look for everything, or they can be more focused, but we can create filters for them based on an industry or whatever. Like if you're like a Planned Parenthood as an example, they would have specific requirements that may be different than somebody else because they only want to see certain things. Yeah, so you can customize it. Yeah.
What about if they have like a very provocative profile, like not PG-13?
Depends whether they're applying to work.
I didn't know how to approach it. Like I didn't feel like I could talk shit about it, but it was like not good. Yeah, because that's scenario. If your clients look at that person's profile, like that's my HR advisor, Chris.
Yeah, so I mean, that is a very difficult question because it really relates to the hiring practices of that business, what business they're in, and like, is there a track record for that? And kind of, again, I don't know. It's very difficult to be like, oh, well, we're not going to hire you because there's this picture of you on the beach half naked, right? But if the idea is that they're a client-facing person, it could be a conversation that, hey.
Along those same lines, kind of to your point, Catherine, like you could be a Kanye West fan. Right now, you're a neo-Nazi, right? And even though you're not, but it looks like it because of what you're interested in when you post on. Is that kind of what you're referring to? Like it can get real squirrely depending on.
Yeah, I would say that's not going to affect the risk score because you're looking for people that are like showing pictures of guns and like violent, like those kind of tendencies. The political aspect of it, they could look at that, but the idea is that the report that we would provide gives the ability to assess those things to make sure that it is actually them. The biggest challenge is how do you know it's them, right? One thing is you can ask them for the profiles, but they're trying to make that a thing of the past as well, but right. So like I said, I don't know. Some people do it because they've been burned, right? They've had people that have posted things and they want to check it retroactively, which is not a good idea, but that's their concern. They want to let people know that they're watching. Other times it's, hey, this is kind of what we stand for, especially tech startups, like it's a big thing, but most run-of-the-mill like construction companies are not doing social media.
So you mentioned that it was an obligation on the employer to provide a copy of the report to the employee.
Correct.
What about if you take on an investor, take on other shareholders? What are the rules there?
So what I'm talking about here would be in the as an employee, an applicant.
So if I'm a company, if I private equity firm, I buy a company.
Yeah.
I want to do a background check on all the managers.
Yeah.
Entire management.
So if it's in California, that would be a triggering event because you can't randomly screen people and you can't retroactively screen people in California anymore. So at the time of the acquisition, if you acquire those employees, you can screen them at that time. Conditional offer, they're going to go from one company, they're going to join the new company, you can screen them all.
If I buy the stock of the company, meaning the employees stay.
Correct. I mean, it's a contractual nuance to you HR people, like I'm not going to say for sure, but there has to be the fact, it's like they become a new hire,